All right, welcome back. Welcome back, welcome back. Everyone, please sign into the attendance when you get a minute. Okay. Questions on your mind? Anything on your mind? I'll remind you, if you wanted to take the midterm and you wanted to come talk to me about it, the deadline I gave you was a week from Friday, the 8th. I hope you guys take me up on it. Only a handful you have, but I would like to see as many of you as possible. Okay. Also a note, if any of you are around, tonight at 6 is the Red Mass. It's a Catholic Mass, but it's meant for judges and lawyers. I'm Jewish, but I always go. It's a nice thing. You see a lot of people in the community. It's right down the block at the Cathedral of the Sacred Heart, like 5 minutes from here, at 6 o'clock. I know there's a baseball game going on a little bit later, so maybe you can pray. Never mind. No, don't do that. That's a waste of prayers. But it's there if you want to do it. It's going to be a very light turnout tonight, I suspect, for the Red Mass. It's just going to be a bunch of Jews and Yankees fans, which is pretty much me on the Venn diagram. All right, I'm going to stop. Okay. I get myself in trouble. Are there questions on your mind? All right. We are finishing our topic of zoning today. And today is a bit of a weird class. You probably read these cases going, huh, what the heck is this? Like, what are these cases we're reading? This doesn't fit in. And it really doesn't. And every year, I consider cutting this class, and I always end up adding it, because I think it exposes you to some things which you may not be exposed to otherwise. I do think it serves a useful purpose. But do not think for a minute that the second case, the Mount Laurel case, is good law. Like, don't think that you can use this anywhere else except for New Jersey. This is a very Jersey thing that every other state has rejected by far. So even though it's not good law in any meaningful sense for Texas, I think it's useful for you to study of how other jurisdictions handle the issues of affordable housing in a constitutional sense. All right. Any questions before we get started? All right. Let me begin by talking a little bit about zoning in general. We've studied since Euclid that courts are deferential to zoning decisions, that federal courts in particular have almost no role in second-guessing land use decisions. Euclid said that you apply what we might call a rational basis review to zoning laws, and so long as it might make sense, that's good enough for the courts. There are some exceptions, though, to this deference. And the exceptions flow from the freedom protected by the First Amendment. Okay? One type of restriction on zoning laws concerns religious use, right? Religious uses. So, for example, you can imagine a situation where a city passes a zoning ordinance that says no churches can be constructed in city limits, right? No churches are allowed. We don't want any houses of worship in our jurisdiction. That would probably raise problems under the free exercise clause of the First Amendment. But let's say the city passes an ordinance that says no commercial properties in our city. We only want it residential. That law would be fine, right? Why is the no churches ban no good and the no commercial ban okay? The answer has to do with the special place that religion holds in our society. Did you study a case in con law yet? Or not yet, but did you study a case in con law called Bernie versus Flores? Sound familiar about the church in San Antonio? Okay. So here are the facts in Bernie versus Flores. You had the city of Bernie, which is outside of, I think, San Antonio, right? It's near San Antonio. and a church wanted to expand. The church was too small, they needed more space. They requested a permit to expand their exterior. The city planning commission denied that permit. They said, we think you're a beautiful historical church, we don't want you to expand it. So they actually sued the city, arguing that the denial of the building permit violated the free exercise of religion, that it burdened their ability to practice their faith. Fun fact, which I learned recently, well, not the newest, but one of the new members of the Texas Supreme Court is Justice Brett Busby. He's from Houston, old friend of mine. His grandfather was a person who denied the church their permit. And I met him. His name was Billy Busby. And he was the one who says, yeah, the church was beautiful. I didn't want to give him the permit. I was like, okay, that was a cool story. All right. They sued the city under what was called the Religious Freedom Restoration Act. Right? The Religious Freedom Restoration Act, pronounced RFRA. Right? RFRA. And they argued that the denial of the building permit substantially burdened their religion. Long story short, I don't need to go through the details. The Supreme Court held that RFRA was unconstitutional as applied to the states, that Congress could not force the states to give building permits and the like on religious grounds. Okay. A couple years later, Congress enacts another law, my favorite acronym in federal law, called RLUIPA. RLUIPA, the Religious Land Use and Institutionalized Persons Act. RLUIPA. What RLUIPA says is that if any property or any jurisdiction accepts federal money, they can't impose certain burdens on religion. Right? So this is still a good law. RLUIPA is still good law. So in general, if you ever have any sort of land use cases, you're litigating it, and your client is a church or a house of worship, you get special protections. And certain land use decisions, which would be just fine for other businesses, are not okay for churches. Keep this in mind, may never come up, but if you ever dealing with the city and you want to maybe tell a church or a synagogue or a mosque how to run their property or deny a permit, you may wind up in federal court. Any questions on RFRA or RLUIPA? Yes, sir.
Class before, I brought up an example of the church that was selling their property to a developer in Missouri City. Could they use that RLUIPA? I mean, under what circumstances could they use that RLUIPA to sell to a developer? Or would, once the property transfers to the developer, would they no longer be able to use the RLUIPA?
Well, if the property is owned by a developer, they can't claim any sorts of burdens. But let's say, I think what you're asking is, let's say they claim a burden, get the land rezoned, and then sell it. Is that sort of your question?
Yeah, because right now it's in the hands of the church. It's like 5 acres or whatever.
I suppose you can be crafty and claim some justification to have land rezoned. And once it's rezoned, the new owner would then be grandfathered in. So I suppose you could do that. I mean, churches do sell their property, I guess, from time to time. All right, questions on RFRA or RLUIPA, my favorite acronym. RLUIPA, it's a great one. Okay. Let's move on to other aspects of it. By the way, your book used to have an entire section on RFRA and RLUIPA. They cut it up. I don't know why, so that's why I'm having to summarize it briefly. Always frustrating. All right. The First Amendment has other provisions, right? For example, the freedom of speech. We've already talked about how the government cannot restrict property solely based on aesthetics. Now, the court has held that appearance is not protected speech. What about having a sign in your window, right? What if the city says you cannot put signs in your window, and then one person puts a sign protesting the war in her window? The courts have held, I think, pretty consistently that certain bans on signs and public displays on your property are a violation of the freedom of speech. You can't prohibit posting signs on your property. Now, this sort of holding isn't very useful, right? Because the city can't put limitations on the size of signs, you know, how big they can be, whether they can be electronic, right? There are restrictions on the types of signs you can use, but they can't have a flat-out prohibition on certain types of signs. You do have cases, though, that are somewhat unique involving for sale signs. Some jurisdictions have actually banned posting for sale signs in your property. Anyone know why? I think I guess why would a city ban putting a for sale sign in your property? I'm sorry? Oh, it's not aesthetically pleasing. That's true. Yeah.
It looks like everyone's maybe.
Bingo. To prevent people from thinking the neighborhood's going to crap, right? That if everyone on the block has a for sale sign, they think, oh man, maybe I should move out also. So it's a way to preserve property values, always property values, right? It's to prevent that. It also helps with something called white flight, where entire areas might fear racial minorities moving in, so all the white people move out. You can't put for sale signs. So there are actually a lot of cases involving for sale signs. Now, I guess with the internet, it's not as important, but the visual of having a for sale sign run from your property sends a very powerful signal. Good, Matt. Any question on the freedom of speech stuff? Again, there used to be a case in this in your book. They removed it. They removed, like every 3 or 4 years, of a new edition of the case book, and they just add cases and they remove cases, but without any input from people who actually use the book. It's very frustrating. If you have a fairly old book, whenever I have a new book, my class is very upset because I'm like, I hate this book. You know, then I get used to it. Then I'm annoyed at the cases they remove. It's always a hard juggle. Okay, so we have freedom of religion. We have freedom of speech. The next case involves the First Amendment, although indirectly. The First Amendment guarantees the right of the people peaceably to assemble. What does this provision refer to? Protests, right? Political rallies, right? The right to demonstrate, the right to assemble in opposition to some policy you may not like. Right? The government can't arrest you for protesting. Right? They can't do that. That's a protected constitutional right. But the first case we have today, Village of Terre versus Boraas, is actually a sign from the Village of Terre. I got someone on the internet sent to me years ago. I don't know where he is now, but he sent me this picture. But the first case from Village of Terre doesn't involve the freedom of assembly. It involves something slightly different called the freedom of association. Now, you can read the First Amendment as well as I can. I've read it many times. And you'll find that there is no freedom of association in there, right? There's nothing in the First Amendment about the right to associate with others. The Supreme Court developed this right in cases based on what's known as substantive due process, the idea that the due process clause of the 14th Amendment protects certain liberties. And one of the liberties protected is the right to choose who you associate with. You might call it a right to privacy or something like that, but it's this sort of penumbral, this unenumerated right to associate with whoever you wish. And the first case considers whether a zoning law runs afoul of this First Amendment right. If the zoning law does run afoul of this First Amendment right, then you don't get rational basis review of the zoning ordinance. You get something a little bit more stricter. But if this right doesn't really apply, then the courts will simply defer to the zoning ordinance. Okay. Questions so far? Yeah, just keep in mind the free speech and religious stuff. You may see it sometimes if you're ever practicing, but unfortunately they cut out your book, which frustrates me. Okay, who's next? Who's next? Are you next? Oh, you're all by alone, but no one else in the row. The row's out. Okay. What's that? Just you. Okay. I won't call you 3 times though. All right. You want to start for me, please, with the facts in Village of Terre versus Boraas?
Sure. So there was Belle Terre, which was a small city, I guess.
It's a village. It's tiny. Yeah. I mean, I have it up here. That's it, right? Oops. Zoom. Whoa, way too quick. Sorry about that. That's the entire size of it. It's just where it's highlighted. It's a waterfront property in a fairly well-to-do area of Long Island, which is in New York. Go on, please.
Right. So they had a
Okay.
Couldn't be like loving property. Essentially, it had to be families and.
How do they define family?
So it had to be one or more persons related by blood, adoption, or marriage, living.
What's the other one? Blood, adoption, marriage. What's that other one? What's the exception?
Sorry.
What type of unrelated people were allowed to live in the property? There's one exception. That's important.
It can't exceed two.
You're right, but who said it? Servants. My goodness, yeah. Domestic, right? Housekeepers, gardeners, cooks, chefs, whatever. Okay, thank you. So the town, which had I think only 700 people, I mean this is a tiny place in New York, enacts this law. And this law says we only allow one-family dwellings. And in those dwellings, you have to be related by blood, marriage, adoption, or servants, right? You can have 2 unrelated housekeepers per property. Okay? Now, who's next? Is it Andrea, you next? Mm-hmm. Andrea, why do you think the village of Belle Terre enacted this law? What was their purpose? What was their goal?
Oh, they're trying to keep low-income people down.
Specifically, what kind of low-income people? This case was 1974. Actually, not necessarily minorities.
Oh, hippies.
Who said it? Yes, hippies. Hippies. The 70s were a very different time. If you remember them, you weren't there. That's a Robin Williams joke. He's laughing. Belle Terre was not too far from Stony Brook University, right? Then as now, college students don't always want to live on campus. And they may choose to live off campus. And they usually live basically frat houses, right? Many people to a home. Their goal was to prevent the students attending the university from living in their community. And the way they accomplished this was by enacting an ordinance that said only related people can live together. That way you couldn't have like 6 or 7 college students cramming into a single house, right? That was like the goal. That's what they were trying to achieve. Laura, did their plan work out? Were they able to keep the hippies out?
Yeah, the court affirmed it.
Oh, I mean, initially, what were the facts here? Okay.
Oh, yeah, it was 6 college kids living together.
Yeah, sounds like a blast.
Yeah, right.
Yeah.
They were served by the village with the order to remedy their violation.
Yeah, what does that mean, remedy? How would they remedy that?
Oh, I guess make them leave.
Yeah, move out.
Yeah.
I guess they go marry each other, but not that would work either.
Could adopt each other.
I was also thinking they also adopt each other. That'd be kind of messy, but I suppose that would work. But they didn't. They basically ordered them to get the heck out of their community. They gave a lease. It was an 18-month lease. Eventually, one showed up, then another showed up, then another showed up, and they were all there living together. None of them related. And the students actually filed a lawsuit. And they argued that the zoning ordinance was unconstitutional. Again, think back to Euclid, right? In Euclid, they zoned the property completely randomly, where there was the part facing the street was residential, and the part facing the back was industrial, and this little sliver in the middle, right? It made no freaking sense, right? And the court said, that's fine, right? As a general matter, zoning ordinances about where one family is, where 2 family is, the courts defer. The only reason why this case was a little bit different was because the government tried to incorporate the definition of a family, right? They tried to define who is and who is not family. What if they just said, Hannah, let me ask you this question, please. What if the government had just said, no more than 10 people who can live in a house, period? It doesn't matter if they're related or not. Would that work? Yeah. What if you have like the Brady Bunch with 15 kids or something? No, they had 6. Never mind. But you had a family with like 15 kids, and they had a fixed limit of only 10 people.
Well, could it be
So even a fixed limit, so I'm getting it, right? Even a fixed numerical limit would still run into problems because maybe you have a really big family, a lot of adopted kids, the Brady bunch and the Partridge family move in together, right? Lots of people living together, but that wouldn't work. Yeah?
How would that work with police power, with health and welfare, especially if you have so many people in such a small
Crowding.
vicinity?
So the way, here, give you this question, Matt. How would you craft an ordinance that limits the number of people who can live in a place, but also has concern for crowding and over spacing?
You'd have to couch the definitions and for reasons to why you're doing it with health and safety of the community.
Right. How would you craft that ordinance?
The special exception?
Yes, but how would you define it, for instance, which crowding? Anyone know? Want to take a guess? Bingo. Say it. Raise your hand. Who's that? Yeah. So you could say X number of people per square foot, right? So for every additional family member, you need more square feet, or you need at least one bedroom for X number of people. That's how you'd probably do this, I think, the most legitimate way. If you're actually concerned about crowding, you would have some linkage between the number of people and the number of square foot you need, right? I think that would make sense, right? Or maybe you have to have more to prevent maybe crowding on the street. You have to have a garage, right, to store X. So for every number of people, you have to have X number of spots for cars to prevent street crowding, right? There are neutral ways of accomplishing this sort of health and safety concern. You don't have too much crowding without having to define the family, right? Kyle, did this statute, as it was drafted, in any way reduce crowding? Did it limit crowding? Why not?
Because
Why did the statute, Kyle, do nothing to reduce crowding?
well, because I
Oops.
guess I suppose you could have a bunch of household servants or something.
Yes, right. You can have a family with 20 people, right? Imagine a huge family with lots of kids, lots of adopted people, right? And they're all crammed to a single family house. That's fine, right? You could have 15 people living there, all of driving age, and they all need cars, right? And they all take up space in the streets. Or you could have 6 college kids who all ride bicycles, right? Who don't even need cars, right? And college kids, they'll fit into the VW Bug, 20 of them in one car, right? I'm being mean, I'm sorry. I have fun when I teach this case. The point is, this statute was in no way directed at reducing crowding. It was in no way reduced at directing, a sanitary condition. Oh, maybe there, I'll stop. It wasn't reduced at improving sanitary conditions. It was designed solely to keep out certain people. That is, those living together who are unrelated. Think of a commune or a frat house or something like that. In some states, I don't know about Texas, sororities are not permitted. Where I went to college in Pennsylvania, the sorority houses were actually on campus. They were dormitories for sororities. Fraternities could be off campus, but sororities cannot. The old story, which isn't true, is that there was some rule saying that a sorority was basically a brothel, and you can't have this. That was not accurate. People say it all the time. It's not true. But at least in Pennsylvania, the zoning ordinances did not allow certain unrelated women to live together, but that law didn't apply to men. Probably subject to a court challenge, but I don't know. Some of you are laughing or chuckling. I don't want to ask. Okay. Any questions so far? I'm not going to ask. Okay. But then we get to Justice Douglas's opinion. Andrew, you want to walk me through Justice Douglas's majority opinion, please?
They found the ordinance involved no fundamental right guaranteed by the Constitution.
Okay, well, first off, Andrew, you're exactly right. They said there's no fundamental right involved. But how would the court describe its approach to reviewing zoning laws? Is it one where the court is willing to second guess the decisions of the elected branches?
It looks like a position of reference.
Yeah, exactly right. Thank you. Justice Douglas employs what you can only call deference. He says the concept of the public welfare is broad, and it's within the power of the legislature to determine that the community should be beautiful, healthy, spacious, clean, well-balanced, and carefully patrolled. In other words, the state has almost unlimited, unfettered power to decide how their community is developed. He writes, miserable housing conditions may do more than spread disease, crime, and immorality. He writes, housing conditions may suffocate the spirit by reducing the people who live there to the status of cattle. They may make living an insufferable burden. They make an ugly sore blighting the community, which robs it of its charm. The misery of housing may despoil a community, as an open sewer may ruin a river. We do not sit to determine whether a particular housing project is or is not desirable. Do you think Douglas likes these laws? Oh yeah, he does. Douglas was the biggest environmentalist in the court. He actually wrote a decision in which he argued that trees should be considered people for purposes of standing, that you can actually have a tree stand in as a person, and the court should appoint people to represent trees. Yeah, some of you may like that. It was nuts back in the 60s. It's still nuts today. People like that stuff. But he was a huge outdoorsman. He loved nature. And for him, the thought of people cramming together, was living in these apartments, was very rough. Now again, if you can only afford 6 people in a house, it's the only place you can live, right? The upshot of this, these 6 people have nowhere to go, right? They live there because that's what they could afford. So these decisions are great if you can afford a nice, spacious house. If you can't, not so good. Query how Justice Douglas would have responded to the Mount Laurel situation. He'd probably been okay with it. Yeah, that's great, having these nice, spacious homes. Maybe not, I don't know. He was dead by the time Mount Laurel's decided. Douglas was a character. He was a Roosevelt appointee. He served for 36 years. He was one of either the longest or the second longest serving justice. I can't recall. But he served for 36 years. Think about it, from 1939 till 1975. That was a long time. You know, he went through World War II, the Cold War, Vietnam. He was through everything. He had a lot of bitter feuds with his colleagues. He became a big civil libertarian. His most famous decision is Griswold v. Connecticut, the contraceptive case you probably studied in con law. He was a bit of a womanizer. He was married several times, and he would often divorce his wife to marry a secretary. This happened a couple of times, and his secretary got older. He'd find a new secretary, marry. Because he was a divorcee, it kind of killed his political career. He wanted to be president, but that simply wasn't in the cards for him. He was a character. He actually became so ill towards the end. He had a stroke, and he refused to resign. He was incapacitated. He would not step down. So his colleagues did something. They said, if you are the 5th vote in any case, we'll just re-argue it. We will not let you cast the 5th vote. So they basically just like walled him off from the court. Eventually he resigned. But my goodness, he was on the bench for a very long time. He also wrote a case we'll study later called Berman versus Parker. Berman versus Parker. This was an eminent domain case from the District of Columbia. Actually, not too far from National Stadium, they used eminent domain to seize a bunch of land for private development. Okay. Yeah, Justice Douglas was a character. Yes, Andrew, you're right. Douglas found that there's no fundamental right to choose who do you live with, and because there's no fundamental right at issue, the zoning law is reviewed with a rational basis scrutiny. Now, just pause for a second. We do have a due process clause that says you can't be deprived of your property without due process of law. This is not just unenumerated, but the court, following Euclid, doesn't treat property as an actual rights of a second-class right. Okay. All right. Any other questions on the majority opinion from Justice Douglas? Okay, the case, is that a question? Okay, well, you're next anyway. I was looking at you. The case, Euclid was, I'm sorry, not Euclid. Terre was an 8-1 decision. Right, it wasn't even close. Usually Justice Brennan would always join Justice Marshall in dissents, but here Brennan wouldn't even go along with it. You have a solo dissent from Justice Marshall. Thurgood Marshall is one of probably the biggest figures in the court in the 20th century. His greatest claim to fame was as a lawyer for the NAACP. He helped litigate Brown and many other desegregation cases. He was later appointed as the U.S. Attorney General, and then was appointed as a federal judge, and then was appointed to the Supreme Court of the United States. What did I say? Not the Attorney General. He was the Solicitor General. I'm sorry. Okay, I'm sorry. No, not Attorney General. Solicitor General. I'm sorry, I misspoke. He was also appointed as a federal judge in the Court of Appeals. Okay. Tony, you want to walk me through the Justice Thomas dissent, please?
Justice Thomas or Marshall?
Oh God, Justice Thomas. I'm going to hell. Justice Marshall. I'm sorry.
Well, he didn't like it. He said it was intruding on the First Amendment due process, and strict protective scrutiny should have therefore applied.
Yeah.
Because the right to establish a home is an essential part of a liberty guaranteed by the 14th Amendment, and they must tell people how to live.
Okay, very good. Marshall explains that there is in fact a First Amendment issue here. And he relies on the freedom of association, which the court sort of sketched out in a number of cases. They never actually define it clearly. But there's some cases that say you have the right to establish your home, which involves the right to direct the upbringing of your children. There are other cases about the right to contraceptive to use in the privacy of your bedroom. Another case cited Stanley against Georgia. See that one said the right to satisfy emotional needs? See that one? Anyone know what that case is about? Porn. Stanley versus Georgia's right to have pornography in your home. Satisfy emotional needs, that's how he describes, I guess. I'm really going to hell tonight. I should go to mass real quick. And of course, the right to privacy that exists. He says that the choice of who to live with and what kind of relationships you have is that belongs to the person. He then criticizes the statute. He says, you can have an unlimited number of blood-related people, 20 people who live together by blood, but only 2 people who are unrelated, right? The village punishes those who deviate from community norms when they choose their living companions. Okay? You fence people out who have a different lifestyle choices. Marshall also explains that this was not a sincere effort to maintain a residential character, right? The city could ban frat houses, right? Maybe they say no more than 10 unrelated people living together. Maybe you can have density rules that says, well, you need to have only so many people per square foot. But this statute is not related to density. It's not related to crowding. It's related to the types of people who can live together, right? Marshall entertains that you can have laws that consider certain factors. For example, population density, noise, traffic, parking conditions, etc. Right? You can have different things to try to maintain the character of the neighborhood. But this statute is over-inclusive, that it includes too much. And you can have a more narrowly tailored statute that addresses these goals without prohibiting unrelated people from living together. He writes that this is a commendable course in a constitutionally faulty vessel. It's a good line. I like that line. Therefore, he reviewed the zoning law with heightened scrutiny and found that it violated the First Amendment. But Marshall was a lone dissenter here. Okay. Questions on the dissent from Justice Marshall? Any other Marshall dissent? There's another case that I think might be mentioned in your notes called Moore versus City of East Cleveland. Moore versus City of East Cleveland from 1977. This case involves a similar law. The city tried to define a family unit, and they said that a person cannot have more than one set of grandchildren. So let's say I have 2 kids. The first kid has a grandson named Tom. The second one has a granddaughter named Sally, right? Under the zoning law, Tom and Sally cannot live with me as the grandfather. right? It basically said you can only live with one set of grandchildren. Why would the city do this? It's kind of bizarre. They want to prevent these sort of extended families from, grandmothers taking care of grandkids for multiple kids. I don't know. It seems kind of bizarre. In this case, Moore was living with her son and 2 grandsons who were not brothers. The court finds that this law is unconstitutional because it went too far to regulate families, right? It went too far to define what a family is. This law in Cleveland slices deep into families and selects categories of who can and can't live together. In some regards, the Cleveland case retreats from Terre, right? Terre is not overruled, but I think it's weakened significantly by the Cleveland case. And if you wanted to ask me which one's the better statement of current law, I'd say it's the Cleveland case and not Terre. Okay, any questions on that? Okay, let's move on. All right, so name tag Grace, let me ask you this question, please, Grace. So if you were a city, right, and you were worried about, all these hippie students with frat houses, coming to live in your town, how would you deal with that sort of issue? Would you say that you can't have unrelated people, or would you maybe do something else? How would you craft your law to avoid these sorts of lawsuits? What would you do? If you were the town manager and you wanted to keep certain kinds of college students and maybe other people from living in your community, what would you do?
Other than making it unrelated persons.
Yeah, you don't want to talk about relations that the courts might find a little bit too dicey. What would you do?
In the book it says occupancy restrictions based on biological or legal relationships.
No, but you don't want to talk about biological. How would you craft a law, a zoning law, to keep people out that's not premised on biology? What would you do? Well, think about it. No. What are you allowed to zone based on? What can you zone based on?
Public health, safety, and welfare.
Okay, good. So what type of law might you draft to keep certain people out of a community? Putting aside whether they're related or not.
Maybe it affects the safety.
How? Okay. So be more specific. I'm sorry?
Like too many people living in one house.
Ah, okay. So what might you draft to prevent too many people from living in a house? What's one way to prevent crowding?
Say that again?
What's one way to prevent crowding?
Crowding.
Crowding. It's on your book. Yeah, up here. What's one way to prevent crowding in general?
Restrict the amount of people per.
Okay, so one way to restrict crowding is restricting the amount of people. What's a second way of restricting crowding?
Restricting square footage.
Ah, space, right? So how might you draft an ordinance to keep out people who maybe want to live together in a tight space? What might you say?
Drafting an ordinance saying only one person per however much.
Okay.
square footage.
Well, what else could you do? Instead of even saying one person per square footage, what might you say in general?
Only a certain amount of people are allowed to live in a certain amount of square footage.
Forget people.
Okay.
You're almost there. One more question. What might be one way of making it more general so it's not based on the number of people? To keep things spread apart. Size. Lot sizes. Okay? What you find today that the most effective way of keeping out, for example, college students, is to have a minimum lot size. Right? That a property must be X number of square feet. When you have a property that big, it's going to be expensive. And when you have an expensive property, as a general matter, wealthy people live there, right? Poor people won't be able to afford to rent a really big property. So you can do this in a couple ways, right? You can say, we're going to limit the number of people who can live there. That looks really shady, right? That doesn't look so good. Or you can say, all property in this jurisdiction must be X number of square feet. Have a backyard and frontage, right? And when you include these sorts of restrictions, you are invariably going to price out certain groups of people.
But that doesn't preclude people from getting like frat houses and stuff, does it?
You may have other ordinances on top of it, I suppose. Yeah, but you may have no more than 20 people or something. There's one case you may be studied in common law called Cleburne versus Cleburne Living Center. Right? What were the facts in that case? You had a group home. I think it was for 13 people. It wasn't huge, but it was a group home for mentally handicapped individuals, and they wanted to have this house in Cleburne, Texas. They applied for a special use permit. The use permit was denied, and the Supreme Court, in a very surprising case, said that that was unconstitutional. Why was the permit denied? They said, well, we're afraid of having these people all living together. They may pose a threat. Well, you can have nursing homes. You can have other types of homes where people can live together in groups. They said, well, maybe that the having these people near school may lead to violence. And, well, that's the students causing violence, not the residents. And the court said that the reasons given were not the real reasons. The real reason they did this was what you might call animus or disfavor of people with mental handicaps. And that's what Justice Marshall is getting at his opinion, right? This wasn't about trying to keep the roads clean or keep the house not crowded. It was about a disfavor of certain types of people. And what you see in these cases is sometimes when the court senses that this is a law designed to harm people, not just to promote public welfare, then they say it's not a legitimate purpose. These are the rare exceptions. Courts generally don't go into second guessing the wisdom or the motivations of members of government. But at least in Justice Marshall's dissent and in Cleburne, they did. Marshall dissented, he didn't dissent, but he wrote concurrence in Cleburne as well. All right, so any questions on that? Yes, sir, Kaylee?
Would having restrictions on the number of parking spaces per drivable age also kind of?
That could work. You could say for every person over the age of 17 to have at least one parking spot. I think that's pretty neutral. I don't think that's designed to punish anyone.
That could eliminate that as well as restricting the amount of your lot space that could be used for parking instead of.
Yeah, I mean, maybe not just parking space, also garage space, right? If you have 5 people, you need a 5-car garage. Is it even feasible? So it could substantially increase the cost. Right, for every person who's of the age of driving has a driver's license, you need to have at least one spot for them. Now, what if the people don't even own a car? Maybe for every car you own,
Per age
yeah,
versus per car.
I think you'd have to. I mean, I think owning a car might be even too stringent. I think you could even do per person of driving age. I think that would even work. That could make it very expensive. Yes, Grace.
So, is it pretty common in Texas to have the related persons city ordinance?
I don't know. Does anyone know? I'm not sure.
I went to school in Lubbock, and there was an ordinance there, and the city came to my house and was like, we got reported on that we weren't related, and he was like, are y'all related? And we said no, and he was like, okay, then you're gonna be evicted unless you can give me a reason why you'd be related. And he's like, we don't check, so if you tell me that you're cousins, then I have to believe you. So he just said that we were cousins. I mean, it was 3 of us, so I just was wondering if Lubbock was a.
Really, in a college, in Lubbock, they said 3 unrelated people. The other people had the same experience.
2 could be related, but 2 out of the 3.
So they basically had the same law as Terre.
Yeah.
Anyone else from Lubbock? Yeah.
No, I was in College Station, and there were 5 of us, 5-bedroom house, but there could only be 4 of us. The 5th person wasn't on the lease.
Oh, so she just.
Got around it.
Oh, so she just paid her share of the rent. Oh. Anyone else? But people are laughing. What? Yeah.
You were though, because I mean, essentially, if somebody bought a home and it was 4 bedrooms, and then they had triplets, you know what I mean? Now they are now evicted from their house. It's not going to hold up in court. Once the kids hit age 16, then they're all evicted. You know what I mean?
You know, zoning laws don't always have to be rational. Maybe you have a hardship of how to get around it. The courts are very deferential. I didn't know about College Station in Lubbock. Thank you. I've been teaching this case now for almost 8 years. No one's ever mentioned that. Glad people are attentive. But that's basically Terre, right? If the court upheld, they didn't say what relations. To be cousins is enough. So you guys just all lied about being cousins.
They just said related, and there was no way for them to check.
That's what the inspector said to you?
Yeah, he was like, even if you don't have the same last name, all you have to tell me is that you're cousins, and I'll leave you alone.
Who reported you? Do you even know?
Huh?
Who reported you?
Our neighbor, like, it was like a family, and we rented a house, and
Oh, they didn't like you in the neighborhood.
Huh?
They didn't like you in the neighborhood.
Yeah, but it was primarily college students.
This is a popular thing in college towns. I'm guessing you have College Station, you have Lubbock. I did not know that. Oh, go figure. Thank you. Anything else on this?
That was my question. So I was like, well, how do they regulate that? So like your experience, I was like, well, I guess they could report you, but.
Look, neighbors complain about everything. Like just, people have too much time on their hands. Were you loud? Were you noisy or anything?
No.
Don't answer.
The other people like parking in front of his house, like people.
Oh, visiting you.
Yeah, but there was only street parking, so.
Parking is a huge thing also in college towns. It's like a huge. I actually paid to rent a guy's backyard for parking spots when I was in college because there were no parking spots available. Yeah.
Can they, well, I know like street parking is public, but when it comes to like parking in front of someone's house, because in my experience, my family's from Dallas, and our neighbor has threatened that like if he sees another vehicle like parked on the sidewalk that his house is on, he's gonna like call like a towing company, and I'm like do it, but like he like
Do it.
set up like what he does is he doesn't use his driver, his driveway, and just parks on the side of the street.
Yeah, this is actually very common. The house across the street from my dad, the same. He yells at my dad when everyone parks in front of his spot, even though it's not his. I'll give you another proper example. You don't have this in Texas, but snow is a huge issue in most of the country, right? What happens if there's a parking spot in front of your house and you shovel it out and you clean up the spot? And then some jerk comes in and takes your spot that you just shoveled out. So at least in Pittsburgh, where I clerked near there, they had a custom where if you put a chair, like a folding chair, on your spot, that was reserving it for you. Now, can you actually reserve a parking spot? Of course not. But once I was looking for a spot near a restaurant, and I parked. So, oh yeah, I found some chair. I just moved the chair. So you got to move it. They're gonna slice your tires. So I quickly moved my car because there are no spots because all the spots have snow on them. But the issue of reserving parking spots for streets is a huge issue with snow. Here, not so much, but it does come up. Imagine you spend an hour cleaning out a spot, and someone jerk like me just kind of swoops in. It's like Pearson v. Post. You know, all the labor you put into it. Anyway, now I understand the chair. All right, questions on Terre? Anything else for Cleveland? All right, the book includes a discussion of what you might call Nimby. Nimby is a phrase that stands for "not in my backyard," and it describes virtually all aspects of zoning law. Right? No one wants anything near them at all. Right? Anything that's different is bad. Has to be exactly the same as they expected. So if poor Grace is living there with her friends, they want, they call the inspector on them, right? I can't believe they called you on. That's awful. They must do that all the time every year, don't they?
I'm not sure, but we got to stay there. We only had like 6 months left.
Oh yeah.
And then when they came back the second time, it was the same people living there. And it was like, so y'all are cousins, and I was like, yeah.
Oh my God, can you imagine that's your job? You guys cousins? Yeah, we're cousins. Anyway, but the book has these different expressions. So you have Lulu. Locally undesirable land use, banana, build absolutely nothing anywhere near anyone, Gumby, gotta use many backyards, Lasby, look at several backyards, Niabi, not in anyone's backyard, Nimble, not in my bottom line, Nim2, not in my term of office, Nope, nowhere on planet Earth, Yimby, yes, many backyards. The idea is no one ever wants anything built near them. Build it somewhere else. But the problem is what if there's nowhere else? What if you actually have a zoning law like the one in Mount Laurel, New Jersey, where it's literally impossible to build, right? What do you do in those situations? Generally, everywhere that's not named New Jersey, the answer is you defer to the government. Okay? Generally, you just don't even talk about the courts. But then we have New Jersey, right? And New Jersey is a very unique place. Their laws are always kind of outside the mainstream. But we'll study this case. Morgan, can you please walk me through the facts in Mount Laurel, specifically how the city's zoning ordinances were set up?
So basically, they had ordinances that divided this area into 4 different groups.
Okay, good.
And so it regulated, I think, the group by lot size and square footage, and essentially made it impossible for low and middle income families to live there or afford to live there.
Okay, very good. Thank you. I have a map up here. It's not very good. I was trying to plot out the area that we're. Oh, why is it zooming in so quickly? Something's on lock. It must be. But this is a place in southern New Jersey. It's right across the river from Philadelphia. This is Philadelphia. This is Camden, and Burlington Township up there. So it's this entire area along this way. Mount Laurel was a pretty rural place. But after the 1950s, the population began to increase. As often happens when the composition of a neighborhood changes, the new people are viewed as outsiders. And in 1964, the city adopted a new zoning ordinance that a huge chunk of the land was zoned for industrial. Most of it wasn't used for that purpose. In other words, you zoned land for industrial knowing it wouldn't be used. A very small percentage was used for retail establishments. Not much was used for retail either. In the R1, R2, and R3, the land was zoned only for single-family detached dwellings, 1 house per lot. Again, single-family means no unrelated people. Detached means you can't have townhouses, just 1 house, 1 house. And you only then have 1 house per lot, and each lot has to be a certain size. Townhouses, apartments, and mobile homes were not allowed anywhere in the township. The upshot is that you could only have houses for middle class and upper class individuals. You couldn't build anything else. There was perhaps some planned unit development, the PUD as it's called, for some sort of developing, but really nothing ever came of it. The land was still too expensive. One of my favorite parts of this regime was that it limited the number of apartments having more than 1 bedroom. And it said no school-age children permitted to occupy a 1-bedroom apartment, and no more than 2 children for a 2-bedroom apartment. So to Stephen's question before, what if you have triplets? I guess you have to move out. Yeah. That's what I was thinking of with your question, right? If you have triplets, I guess you have to move out. You can't live in your place anymore. My favorite part is there was a covenant that if you have more than 0.3 children per multifamily unit, you have to pay the tuition for the additional kids, which is insane. This will never happen. So the town conceded that these sorts of restrictions were not lawful, right? They agreed. But you still had the issue of the lack of the lack of multifamily property. Now let me just give a little background on how litigation usually works. This case is brought by the NAACP, which is a civil rights organization. It was brought on behalf of people who did not live in this township, right? The reason why is that there was nowhere in this township for these people who wanted to live. In other words, people who lived outside the area who want to move in, right, sued saying we have nowhere to move. Now this is a very unorthodox lawsuit. generally, you can't go to federal court to complain that you want to move somewhere when you don't live there. Generally, you can only challenge the rules of the place where you live. But the New Jersey court sort of created an exception here, saying, well, we'll relax these rules of standing because we consider housing to be a statewide function. So basically, the entire state is considered as a whole. And if one part is exclusionary, people who want to move there can then go to court to challenge it. The court says we'll consider the case from a wider viewpoint. Okay. The court also considers whether this ordinance was adopted with the intent to exclude people based on their race. And the court finds that's not. Right? This is not an ordinance that said, we're going to segregate because we want to keep out black people. This is not Shelley versus Kramer. Instead, they look at the intent, right? The intent was perhaps neutral, but the effect of this law is to keep out predominantly African-American homeowners, right? Even though there was an intent to keep people out, the effect of it was to be discriminatory. As a result, the court finds that they can resolve this. The last point I'll mention before I call on, I think, whoever's next, Elliot, I'll call on Elliot in a minute, is this was a case brought under the state constitution, not the federal constitution, the state constitution. Every state has its own constitutions, and in many regards, the state constitution provides more protection than the federal constitution. A recent book described our country as 51 imperfect solutions. You have all these really good state constitutions. Most people ignore them. Right? Most people focus exclusively on the federal law. You shouldn't. If you're ever in state practice, always think of the state constitution. May give additional rights that your client can benefit from. Always think about it. Okay. Elliot, you want to walk me through the court's opinion? There's a lot going on here, so wherever you want to start, I'll figure out where to go.
Well, the majority said that if the effect of the ordinance is to prevent low-income and moderate-income families from residing in the town, then the ordinance is unlawful.
Okay. The crux of the court's opinion here is whether the city made it realistically possible to have low-income housing. And the city cannot foreclose the opportunity of low and moderate housing. Right? It doesn't matter if this was their intent. Right? What matters is what the effect of their decision was. And here they said that the courts has a role to enforce the police power. And the police power affects the welfare of the people. And the court includes in the concept of welfare benefit to low-income people. In other words, we've generally viewed the term welfare to mean property values, how spacious, how not crowded it is. But the court here says that welfare also consider the welfare of the low-income people who live outside this area. So the court here expands the scope of what welfare is in many ways that's in tension with all the other decisions about aesthetics and building quality. Okay? The court says that housing is an important need, the most basic human need, and that the city cannot adopt plans that thwart it. Okay. Grant, let me ask you this question. According to the court, is it enough to merely is it enough to merely declare the zoning ordinance unconstitutional? Is that enough?
No.
What must the state actually do, or the county actually do?
They have to have a zoning that affords the low-income families an opportunity to have housing.
Okay, very good. They use a phrase, affirmative action, which you may have heard of, may not know what it actually means. The concept of affirmative action took root in an executive order signed by President Kennedy. And the executive order said that in federal contracting law, the government cannot discriminate on the basis of race. But that wasn't enough. The government had to take affirmative action, that's positive steps, to ensure that minorities had access to these contracts. Right? Affirmative action means you have to go beyond just allowing it to happen. You have to make it happen. So the bulk of the decision was not merely saying about whether these zoning laws are unconstitutional. The bulk of the decision said that the city needs to take steps to develop affordable housing. Right? The city must take steps to zone to encourage development. right? They cannot only zone to promote property values, they have to zone to encourage places where families can live with their children, right? They must permit multifamily housing, small dwellings, low-cost housing, high-density housing, permit zoning near commerce, right? They must actually take affirmative action to deal with this issue. Okay, so the court made its ruling. All right, questions so far? So Natalie, what was the actual order the court said? What did the court order the city to do?
They must, by its land use regulations, make realistically possible the opportunity for an appropriate variety and choice of housing for all categories of people who may desire to live there, including those of low and moderate income, must permit multifamily housing without bedroom or...
Okay. How much time do they give the cities to actually do this? This is kind of funny thing at the end.
90 days?
90 days, that's it. Do you think they did it in 90 days, Natalie?
No.
No, not even close. Right. So the court here was maybe being a little bit optimistic, right? They said, we'll give you 90 days, and then you can correct your deficiencies. And then you come back to court, and well, the court will review it. So we'll let you try it on your own first, but if we're not happy with what you do, the court's going to intervene. The aftermath of this was an absolute disaster. It did not work well. Initially, this is discussed in the notes afterwards, initially the town of Mount Laurel read the opinion narrowly. And they said, well, we'll only apply this remedy to certain types of developing communities. They did not really want to comply with it. Right? So in other words, they zoned for low-income housing to 3 scattered lots, which were not very useful. They were near industrial. Okay, went back to the courts. The court said, no, 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 this is not necessary, and this is not appropriate. As a result, the court applied what they called a strong judicial hand, right? Where the court began to actually regulate the property. They said, here are the zoning laws you have to adopt, right? They said that cities have to take affirmative measures to develop the property. And eventually, the trial court would basically tell developers what to build. This went on for years and years and years, 20, 30 years, where the courts issued all these demands to the city, and the city fought them at every step of the way. Eventually, units were built, but not nearly as many as the court wanted. So this litigation went on for years and years and years. Okay. All right. So questions on Mount Laurel? Questions on Mount Laurel? Again, don't take this case as some sort of majority rule. It's sort of an outlier, and most courts have rejected this approach. Generally, when a city zones to keep property values high and keeps that low-income family housing, that's the end of the road. You don't get around it. That's why zoning laws are very hard to break apart. Okay, are there questions on this topic? All right. Let me give you a preview a bit for class that starts on Thursday. We're moving on to a new topic called takings. Right? The takings doctrine is based on the takings clause. So far, we've been talking about zoning laws, which tells you generally how you can use your property. The next batch of cases involve more stringent uses of land use, not what your property looks like or how big must it be, but what can you do on it. That is, can you build? Can you dig for coal? Can you build a tower? Right? And these are cases that decide whether the government needs to provide compensation for restricting your land use. The topic called regulatory takings. Any questions? No, I'll be in my office if you want to come up. Thank you.